This guy over here, his name is Jose Noriega, and he is an attorney. I am Robert Guest. I am also an attorney. You know, just the
I have my bar card, even though I am quarantined. Robert cannot
is
say this. Robert cannot say the same.
what I'm quarantined. Or I do have a bar card. It's in my wallet, and I could
Well,
get it.
the
This is
audience
in the
can't
other
see it,
room.
can they?
No, but you can look me up on the Texas State Bar website. And as you can tell, just by like the brilliant legal insight I have been licensed longer than Jose.
And while you're Googling his name, though, look at his UIL championship for writing ability. Just so I want to throw that out to the audience that they are
That's usually
well
why
aware.
why they hire me, because of the work I did in high school. They're like, this guy has been
The
testing
1994-95
25.
Entertainment Review UIL Champion of Texas. Robert Guest, everyone.
Do you have an applause button you can hit?
Well, I'm going to include that in this video because right now.
Yay! And like confetti.
Yeah.
Oh, yeah. Graphics. What we're going to talk about, if we can ever start this tape, is punishment hearings. And especially as we're talking about, we've had an open plea talk earlier, but we're going to talk about if you have a case set for trial and your lawyer's like, we got to get ready for punishment, why you have to do that, what it means, and what you need to do to be a good client. Because I think when we talk to our clients about punishment, they think, well, are you assuming I'm going to be found guilty? It makes them a little skeptical of our motivations, right? But the thing is, especially on a serious felony case, because Jose is going to talk about working out a deal sometimes after guilt innocence, you don't have to have punishment hearing. But on a felony case where, you know, the result could be decades in prison, you have to have a deliberate punishment strategy to show why you shouldn't get, you know, a bad sentence, a worse sentence, why you should get a better, or if you're probation eligible, why you should get probation. And so what I like to tell clients is early on, if I think this could be an issue, if I think we could end up needing this, is let's start identifying character witnesses, right? People who can come to court, who know you, and they're like, well, who should I get? And I say, well, who's like the most important person who's known you the longest, who like isn't just your relative? Because relatives are okay. But like, I don't see judges really super persuaded by like mom or, you know.
Yeah, I have yet to find a client that mom is like, oh yeah, he needs to go to prison, right?
I did
I mean,
when I was
moms are always, you know, very sympathetic and loving and everything like that, which is great. But judges have seen that a million times, right? I want your neighbor from down the street that you go over to mow their yard every Friday.
Yeah, or like
you're just a nice person.
Like, did you have a job? Who's the most important person at your job who knows you the best, who can talk about you like they know you, right?
Yeah,
that can be persuasive.
That you show up to work at 7:00 when your start time's actually 8 a.m. Like that you're there late. That you took over 30 people's projects to do that. That shows a little bit more than what
I did. Speaking of moms, when I was in law school, one of my jobs was I had to summarize like death penalty journal reviews from law journals and just from like other studies on the death penalty. And the question was, does it help you if your mom shows up at your death penalty sentencing? And they did a big statistical analysis. And what they came up with was, it doesn't really help you if she shows up and testifies, but if she doesn't, the jury has negative connotations. They're like, where's his mom? Did something happen to his mom? And so you always bring your mom, death penalty case, bring your mom. And so when I tell clients, you can have these witnesses, you can definitely have your mom, you can definitely have your wife or something, but I don't know if they're going to sway a judge as much as somebody else. Because what are you trying to say is, this is a person who, with the goals of punishment, you know, like rehabilitation, punishment for punishment's sake, you know, deterring other criminals, protecting the public. You know, can they say something beyond, well, I just think you should get a break because I like him? They need to be able to kind of articulate things about you. Like they need to be able to humanize you. Like I tell them, like, what's like the best story you can tell me? I've asked witnesses this, like, if you're going to tell me the best couple of stories about this guy, the things he's done that show who he is, what would that be? And you can have them like fill out a form and stuff. And like coworkers, I think, are good for this. I know pastors are popular, people like that, you know. If your client's in some kind of counseling or treatment plan, those people are good too.
I would go with coworkers and then counseling treatment. Unfortunately, a lot of people tend to kind of go to their pastor immediately after a crime, especially one that's having severe consequences. And I think that, or possible consequences. And I think that judges are kind of immune to that now, just because it does, they testify so often. I mean, and they're great to have, don't get me wrong, but
yeah, it's better than not having one. You're right. I think it's like a mom. I think the impact is just like, it's your pastor, dude. They're going to like you. But, and then you're kind of going, well, how many witnesses can I get to make this impact? And so early on in the case, if your lawyer asks for it, get them a list of the people, like we've talked about, who know you the best, because you could have to have a sentencing hearing. And so I'm going to let Jose talk a little bit about, though, like some cases, you're found guilty, your sentencing starts like then. And so like the jury's there, they're like, go, defense lawyers. You don't get a break of like a week to call your witnesses. You need them ready to go because, usually it's like the next morning you're going to start. So you got to get them all there. The logistics are so challenging for this, but sometimes you don't even need a sentencing hearing. So Jose, tell us why we might not need one.
So the way that I explain it to clients is, hey, look, it's not that I'm not worried about guilt, innocence, or that, anything like that, or I'm focusing on punishment only. It's that I can be held what they call ineffective assistance to counsel if I don't prepare for punishment, right? So not only do I have to prepare for guilt, innocence, and whether you're guilty or not guilty, I have to prepare for what the punishment should be in the event that you're found guilty. And so it's always a scary little thing. And clients will get mad at me even sometimes when you sit there and say, hey, look, man, I need at least 4 or 5 witnesses,
why? For what? For punishment? You think I'm going to lose?
Hey, I need you to be doing some therapy for this, or, something along those lines. And they just kind of look at me like I'm crazy. And I'm like, no. Like, I agree we have a strong case here, but ultimately it's up to 12 people to decide that. And I'm not one of those 12 people. And so, we need to worry about this just as much as we have to worry about that.
And that's something I think too, as defense lawyers, we don't like nearly as much preparing for as we do for the trial, the evidence, the objections, the arguments. It's something that it's a totally different gear, and it's mentally completely different than going, we're fighting everything the state's saying, because after it's been declared you're guilty, because we started this day with an earlier talk about an open plea, which is different. You're conceding guilt. But if you've been fighting on guilt, innocence, and the jury and judge comes back guilty, right? It's like you have to switch gears going, okay, now we have to accept that we did it because legally we did it, right? And the whole time you've been fighting going, no, we didn't. You're really taking a different angle on the case. It's to the point where sometimes I like having different lawyers there to argue punishment because it's such a different look.
Absolutely. So I think having a different lawyer do the punishment case is often beneficial. I think that, it's always just this weird dynamic. I've had a, guilt, innocence trial with punishment trial go in, and it's, hey, like you stand up for opening arguments again for the punishment phase, and you sit there and say, well, I disagree with your verdict. I respect it, or something along those lines. When, in all honesty, I mean, in your head, you're just thinking like, you got it so wrong. Like, you got it so wrong.
It's you've been fighting for days over this and you believed in your case, you believed in your client, and you've just been told, no, dude, you're guilty. And the same jury, you got to go back in and go, what am I going to do now? Because, all your great ideas you had when you're brainstorming with your team, rejected. And it hurts when you're a defense lawyer because like, these are my ideas. Like, and defense lawyers, we can get this really optimistic, like maybe we're going to win this thing, right? Maybe we're going to get it. And we always think that way because, we're trying to find a way to help our client, and we're working towards this goal. You make it the goal and you try to make it a reality, and then you get told no. And all of a sudden you're going, well, we're sorry we did it now, which is different than we didn't do it. Those are two different stories.
Or you don't even necessarily have to say, I'm sorry I did it now. But yet you have to come up with, hey, I'm a redeemable person. I mean, that's the number one thing, in my opinion, that you have to show, right? I mean, you have to sit there and say, hey, look, even though I contest whether that cocaine was mine, I've been going to drug class and doing all these things. And, I've got a bunch of witnesses that show that I'm still a productive member of society and can be a productive member of society.
Or how about when your client testifies of guilt, innocence? And that's really tough.
That's one of the hardest preparations you can have as a defense lawyer.
And then they found guilty, and you're like, should I have them testify in punishment? Because what's implicit in that guilty finding? They're going, don't believe you, dude.
Yeah, we don't believe anything you said, and
we've all been there. And you're going, now what? And you're kind of on your heels a little psychologically because you feel like you lost. I mean, it's a binary system.
I remember
There's only two results.
My first murder trial, and client didn't testify in guilt innocence, but all of a sudden he testifies in punishment, and it was literally a completely different story. I was second chair or third chair even, and which means I wasn't really in charge of the trial. And it was a completely different story than what we had argued during guilt innocence, and we were just like, okay, now we're losing all credibility in this. And so
you can see it happening in real time, and you can't stop
it.
You can do nothing. You're going, oh my God, and you're just
like, oh wow,
all that work, all that fighting, and you're just seeing it crumble. And let's talk. I want to circle back because we ran through something that we mentioned in like the first video that we decided we didn't like. Now we're going to do it again. But tell us about cases where the punishment idea can be, we're going to work this out if we're found guilty.
So it generally happens with either a mandatory probation type of case.
Like what?
If you've got if you've never been convicted of a felony before and you've got a drug case, right? Less than a gram cocaine. That's what they call a state jail felony. And so if you're found guilty, the judge has to give you probation, or he has to probate a jury sentence. And so in that situation, oftentimes you can agree with the prosecutor, hey, look, we'll waive appeal, just give him 2 years probation, right? And you have to speak with your client about it and let him know, like, hey, the fight's over if you want to take the 2 years probation. If not, the judge can sentence you anywhere to 5 years probation. It happens more often with misdemeanor cases.
A lot of the times.
Because
you see it because they don't want to they're like, this is a misdemeanor, we're not going to do a full blown. And it's kind of looking at weird if the state is just itching for a misdemeanor punishment hearing. Like, yeah,
it is. It's a very odd situation. It's kind of like, all right, I mean, it's a DWI. Like, what you're actually going to seek, 6 months or a year in jail? Come on.
Yeah, they're going to ask for like a bunch of time on this. You're like, no.
But there used to be a prosecutor who would file like enhancements on that.
Well, he would. He would ask for his time, and you'd have a hearing.
Yeah, and so, but just nowadays, I mean, almost every court that I've been in, I've seen where prosecutors and defense attorneys will agree to the punishment and say, okay, hey, we'll do 18 months probation or 24 months probation, and fine him $1,000 and
it's
we'll
like
waive our appeal.
A little bit worse than the normal plea deal, right? That's kind of seen as like the starting off point.
It's generally more expensive than the normal plea deal. I think that's kind of where they want
20% worse, right? Yeah, as your punishment for having this trial.
Yeah, the main thing on that though is when you can get deferred before the plea, before whatever the plea offer was. So if they were offering 18 months deferred probation where you weren't convicted, if you've been found guilty at trial, then you're convicted. And so that does make a difference in why you would, consider the 18 months prior to the trial versus afterwards. For cases like DWIs or something along those lines, honestly, I don't see it. If your punishment's going to be 20% more, give or take, what's the point in pleading not guilty immediately, right? I mean, unless they offer, a substantially less term or where you save a ton of money or do something along those lines, there's no reason to just go out and plead guilty.
Let's talk about on more serious cases too, because I mentioned that, sometimes you go straight into punishment. On felony cases, after you're found guilty, you have to do this thing where
Can you see my name on here, by the way?
Josie. They try to they'll ask the judge, like, now that you're guilty, your bond's insufficient, right? And so they can really put you on your heels going, oh my God, we're just fighting to stay out of jail, right? And there's some things we do to try to get us some time to like react to this. We're like, can we have a PSI done, please? Can we come back for a hearing? Because they're right. If you're found guilty, the state can go, your bail's no good anymore. Back to jail for you while we wait. And you can have a hearing on that. And for some cases, like they'll assume like they should set it really high. Like if it's over like a 10, if you're like a 25 to life or something, like you're going in, right?
I think different judges have kind of different opinions on that. It's so weird to me because sometimes you'll see judges that hold the bond insufficient, or the bond is what they call discharged immediately after guilt innocence.
And you're like, no, let's just carry this bond through. Please.
Exactly.
So we're saying.
Where they'll kind of sit there and be like, hey, just let us stay out. Odds are that doesn't happen after a guilty verdict, though.
No, it's tough. And you got to know your judge and you got to know your case. I think we've covered our punishment topics. Anything else to say before we sign off on this one?
No.
All right. Well, thanks for watching. It's Robert Guest, Jose Noriega, guestingray.com, 972-564-4644. Thanks.